Good morning. My name is Jack Lavin, President and CEO of the Chicagoland Chamber of Commerce. Thank you for joining us for today's webinar, The Future of the Biometric Information Privacy Act. I know we are all gearing up for the holidays with our family and friends. However, as soon as the calendar turns to 2022, the Illinois General Assembly will be returning to Springfield for its spring legislative session. We do expect a robust and busy session despite a projected early adjournment scheduled for April 8th. The Chicagoland Chamber and our many partners in the business community will be working on a number of priorities next year to continue to support the state's economic recovery. One area of reform that is essential to help businesses immediately without additional state or federal funding is the area of regulation and civil liability, which year over year places a great burden on businesses across Illinois. There is no clearer example of regulatory laws in need of reform than the Biometric Information Privacy Act, also known as BIPA, which has been weaponized in recent years to go after businesses, particularly and increasingly small businesses. Enacted in 2008, BIPA made Illinois one of the first states to devise a broad and comprehensive privacy protection law dealing with the handling of biometric information. Like many laws passed in Springfield, however, this perhaps well-intentioned legislation has resulted in some rather egregious unintended consequences. BIPA is both penalizing businesses for ensuring safety and security in their facilities, and it is also prohibiting innovative technologies from entering the Illinois market. Companies are being sued under BIPA even when there are no economic damages. In fact, over 75 members of the chamber either have been sued or are being sued under BIPA, significantly raising their cost of doing business in Illinois and costing jobs and economic growth. The Chicagoland Chamber will continue to strongly push for immediate reforms of BIPA in Springfield, and we are excited to have today's conversation with our panelists and members of the chamber. To our members, we will need your help in advocating for reforms. Opponents of BIPA reform are well organized and influential, particularly with the majority parties in Springfield. This virtual event today hopes to be informative and instructive in sharing some ideas for ways to reform this law. We are joined today by three distinguished guests who will share their unique perspectives on the law and the push for BIPA reform. We are excited to have with us Illinois House Republican leader Jim Durkin, who has been a true champion of the business community in the fight to reform BIPA, including sponsoring important legislation last year. Katie Lennox, Associate Attorney with McGuire Woods, who has an incredible wealth of knowledge and expertise on the case law surrounding BIPA. And Jason Speaks, Director of Government Relations with Leading Age Illinois, one of the largest and most respected associations of providers serving older adults in Illinois. A huge thank you to each of you for spending part of your morning with us today. I do want to give also a special thanks to Leader Durkin in particular for your partnership and strong support of the Chamber and the business community on all issues throughout the years. Before we kick it over to our guest speakers, I would like to pass it over to Brad Tietz, Vice President of Government Relations with the Chamber, to give a quick legislative overview and update on BIPA. Brad is doing an outstanding job fighting for the interests of the business community. Again, thank you to our guest speakers and our valued chamber members tuning in this morning. It is with your strong support that we are able to bring together critical stakeholders as we are today to discuss and then advocate effectively for some of the most important issues impacting the Chicagoland business community. Brad, I turn it over to you.
Great, thanks, Jack, and good morning, everyone. Again, Brad Tietz, VP Government Relations with the Chamber. Thank you to all that have joined us this morning, and a big thanks to our guest speakers today. Before we begin, I do have two housekeeping items. First, this webinar and the contents of the webinar are for informational and advocacy purposes only and should not be considered legal advice. Secondly, there will be time for Q&A after we've heard from our three speakers. Please feel free to input your questions as they come to mind into the chat function at any point during this presentation, and we'll make sure your questions get asked. Before we turn this over to Katie with McGuire Woods, like Jack said, with McGuire Woods, I did want to kind of give a brief overview of what transpired last year and kind of set the stage. in terms of what our advocacy efforts have looked like and the legislative history. So as Jack mentioned, BIPA was enacted in 2008 to regulate how companies collect biometric information from both consumers and employees. Not only does it apply to the facial type scanning technologies used by tech companies, but it also applies to small businesses that utilize fingerprint and thumb scanning technologies for employees to enter and leave their facilities. Katie will get into the specifics shortly, but the law has the most punitive private right of action provisions in the country, which have only been amplified by court decisions at both the federal and state levels. As a result of these provisions and court decisions, we have seen an avalanche of lawsuits. From 2008 to 2019, which was the year the most controversial court decision came down, there were 173 class action lawsuits filed under BIPA. Since 2019, there have been more than 1,000 class action lawsuits filed, increasingly, as Jack said, against small and mid-sized businesses. As of July 1 of this summer, nearly half, 46.7% of the suits were against employers of 500 or less employees. So despite what opponents of reform say, this is not limited to the global tech companies. So last year, as Jack mentioned, Leader Durkin introduced House Bill 559, which makes a number of changes to the act. Most notably, it provides for a 30-day notice and cure provision. That is, if a company is made aware of an alleged violation, it has 30 days to cure that alleged violation. With Leader Durkin's leadership and advocacy and lobbying from the chamber and others, we were able to pass House Bill 559 out of the House Judiciary Civil Committee by a vote of 10 to 5 to 1. This was the first time a BIPA reform bill since 2008 had been heard in committee, much less see passage. Also, it's important to note, and Jack mentioned that opponents of reform are well organized. There were members of the House Judiciary Civil Committee whose district offices had received over 200 phone calls from constituents connected with ACLU, for instance, just to give you a sense of what we're up against and why we need members of the chamber and other businesses to help us lobby for changes. Unfortunately, the bill was not allowed to be called on third reading in the House, and I'll let the leader get into that in greater detail in a little bit. There were several other attempts during the last session. We tried an attempt in the Senate Bill 72. There was an amendment that was introduced with the budget implementation bill, but once some of the opponents of reform were made aware, it was removed at the end of session. We have met with a number of the opponents of reform, ACLU, SEIU, and others, and there are very easy ways to incorporate some of their suggestions into the legislation. And I do believe there is a sense of urgency here. There are only so many businesses that these law firms can, sue before everyone hopefully is in compliance in a few years. But in that time, the next 3 to 4 years, we need to make sure that businesses are aware of BIPA and are not facing legal action. All of that notwithstanding, it is clear we are making progress. We have members on both sides of the aisle that have introduced bills to reform BIPA, and we know that members on both sides of the aisle are hearing from small businesses, nursing homes, assisted living facilities like Jason's in their districts. And with that, I'd like to turn it over to Katie Lennox with McGuire Woods. Katie is an attorney with McGuire Woods LLP Labor and Employment Department. She advises and represents clients in various areas of employment law before state and federal district courts, appellate courts, the EEOC, and other agencies responsible for investigating workplace discrimination and retaliation. Katie was critical in the success we had last year, serving as a trusted sounding board on changes we were looking at and helped draft language that we have introduced. Thanks again to Katie, and I'll turn it over to you.
Good morning. Thanks very much, Brad. Thank you for having me. It's an honor to be able to speak with you all this morning about the Biometric Information Privacy Act, some history on it, some current cases, pending appellate issues, and the need for reform and how reform could assist employers. As Brad mentioned, we've been handling at McGuire Woods a number of BIPA cases on behalf of employers, and obviously seen a rise in those cases over the course of the last few years, and correspondingly seen a rise in Illinois appellate court action very recently on these cases, which I'll discuss with you here today. So just an overview on the next slide of what we'll be chatting about today. And as mentioned, we'll just go over BIPA and how to comply with BIPA, the cases and pending appellate issues, and how reform could assist employers. On to the next slide. So as has been discussed, BIPA spans and protects a wide range of biometric privacy or biometric information rather, most notably for employers. Fingerprint scanning systems are implicated in BIPA, and a number of other states followed after BIPA was enacted in 2008, and a few cities as well. However, on the next slide, I discussed that there's the majority of other states have introduced but have not yet enacted BIPA modeled legislation. And you can see here from the dates that a large majority of them have occurred in 2019, 2020, and 2021, so the last 3 years. But many of these statutes still remain pending, and it remains to be seen whether they'll actually be enacted into law. And then on the next slide, as you can see, there's several other states that have rejected, in essence, the BIPA modeled legislation, some finding it too broad, and are addressing biometric privacy issues, which are important issues to address, but they're handling them through existing personal information privacy statutes or other such more specific legislation to data privacy issues. There are only, on the next slide, I addressed that there's only 2 states that have passed this BIPA type legislation where there's a private right of action. California and Illinois are those states. And California, surprisingly perhaps, the private right of action is much more limited. It protects data breach type scenarios, where Illinois' private right of action is all encompassing for all sorts of biometric privacy issues. In addition, the statutory damages in Illinois are quite high, being $1,000 for each negligent violation and up to $5,000 for intentional or reckless violations. Next slide, please. So how to comply with BIPA? There's basically 5 main components for a business to comply with BIPA. One of the first components is adopting written policies and procedures. And while this might seem simple, the kind of hook in BIPA that many plaintiffs' attorneys firms have caught on to is that these written policies and procedures not only need to be adopted by businesses, but they need to be made publicly available. And that's a prong that we see many employers have either overlooked or just not paid particular attention to, and that they might have particular biometric data privacy policies in place or confidential information privacy policies in place, but they haven't made these publicly available on their websites or otherwise, which opens them up to potential BIPA class actions. And the second very common compliance issue is obtaining consent. Companies cannot collect or obtain biometric information until they've informed the subject that their biometrics are being collected, why they're being collected, how long they're being collected and stored and used for, and obtaining a written release from that individual. So simple enough to obtain a written release, but if you don't do it prior to the collection, you could be subject to suit under BIPA. Additionally, companies may not sell, lease, trade, or otherwise profit from a person or customer's biometrics or biometric information. And likewise, companies may not disclose, redisclose, or otherwise disseminate a person or customer's biometric identifier information unless the subject provides consent or other less common exceptions, such as the disclosure would be involved in a financial transaction. It's required under state or federal ordinance or required pursuant to a subpoena. Additionally, companies in possession of biometric information must use an industry standard of care when storing, transmitting, and protecting such information disclosure. And the standard must be at least as protective as the standard the company uses for other confidential and sensitive information. So those are really the 5 main prongs for BIPA compliance, but of course, easier said than done. So to get into the types of cases that are filed under BIPA on the next slide, this is a prime example, the Rapay case versus Hyatt, of an employer suit. Here, Ms. Rapay was a former Hyatt employee who was required to clock in and out using a fingerprint timekeeping system, and she alleged that Hyatt did not obtain the necessary consent before capturing her fingerprint data. She also alleged that Hyatt did not maintain any policy on the use of employee biometrics, or that it otherwise did not inform its employees about the use, retention, or destruction of said data, all in violation of BIPA. This case was stayed for quite some time, but ultimately Hyatt recently decided this past summer to settle the case for approximately $1.5 million, which equates to payments of approximately $1,500 per class member, which is not an uncommon amount per class member that we've seen in recent BIPA cases. However, the next slide shows an even larger settlement. And of course, Hyatt and Facebook are both large companies, but as Brad mentioned at the outset, these suits are not only targeting large companies, but all employers across Illinois. So the Facebook settlement was one of the largest settlements for a privacy violation ever. $650 million for the total class settlement, which equated to about $345 for the millions of class members who were involved in this litigation and who had alleged that Facebook had stored their biometric data for purposes of tagging photos on the website in violation of sections 15A and B of BIPA. Of course, the next slide discusses Rosenbach versus Six Flags Entertainment, which has really been a pinnacle case in BIPA litigation. Brad mentioned it at the outset as well. It's the first Illinois Supreme Court case to discuss BIPA and opine on it. And it discussed whether under BIPA, a technical violation of the statute alone is sufficient. This is because BIPA provides that any person who is aggrieved by a violation of its provisions shall have the right and may recover for each violation under BIPA. Based on principles of statutory construction, the Illinois Supreme Court found that the Act's language allowed for a technical violation alone as sufficient to bring a claim under BIPA. And this is significant. This was a significant victory for plaintiffs' attorneys. Many employers attempt to, if possible, remove BIPA claims to federal court, looking for perhaps a better forum. However, this Rosenbach decision, which allowed for plaintiffs to bring claims for technical violations alone, may allow parties to skirt Article 3 standing in federal court and have cases kicked back down to state court where they perhaps prefer to litigate them. And I'll get into that a little bit more later on here. The next case, Timms versus Black Horse Carriers, was a significant recent decision in the First District Appellate Court in Illinois. BIPA is silent on the statute of limitations that an individual may heed to bring a claim. And the court found that BIPA's statute of limitations varies by section. Specifically, it found that claims under section 15C and D of BIPA are subject to 1-year statute of limitations period, while claims under section 15A, B, and E are subject to a 5-year limitations period. Obviously, this is kind of a mixed bag here for employers, C and D being a 1-year limitations period and the other provisions being 5-year. However, this statute of limitations issue remains unsettled. There's another case pending in another Illinois appellate court which has the potential to come down with a varying opinion on the statute of limitations under BIPA. And so we could see this issue proceed on to the Illinois Supreme Court potentially, unless, of course, the legislature speaks to the statute of limitations. The next case is actually a federal case discussing BIPA, a recent federal decision on September 20th of this year. In the Fernandez case, the Seventh Circuit affirmed a district court decision to dismiss the lead plaintiff, Mr. Fernandez's class action BIPA case on behalf of himself and other employees. He had alleged that his employer, Carey Inc., did not obtain consent before, again, requiring employees to clock in and clock out with their fingerprints. And the case was removed by Carey Inc. to federal court. However, the Seventh Circuit agreed with the district court that Mr. Fernandez's suit was preempted by the Labor Management Relations Act because resolution of the case depended on interpretation of the collective bargaining agreement between Carey Inc. and Mr. Fernandez's and all the rest of the employees in the class, their union. So this was a win for employers, this recent decision, but only pertains to employers who are unionized. This opinion doesn't provide protection to smaller employers or employers that do not have unionized workforce. Somewhat of a victory isn't hopeful for, or helpful rather, for the vast majority of employers that are dealing with BIPA claims. So what are the pending appellate issues related to biometric information privacy statutes and BIPA in particular? Well, as mentioned, there's the statute of limitations issue, which is currently pending with a decision in the Third Circuit, although this decision has been stayed pending an Illinois Supreme Court decision, which is the McDonald v. Symphony of versus Symphony of Bronzeville case. And that case discusses whether the Illinois Workers' Compensation Act will preempt BIPA claims. That case recently had oral argument, and so we're awaiting a decision on it. I was looking this morning to see if anything had been issued. Nothing has come out yet, although the next set of anticipated Illinois Supreme Court opinions is expected on December 16th. So there's a chance that employers could get an early Christmas present from the Illinois Supreme Court if the court decides in the Symphony of Bronzeville Park case that BIPA claims are preempted by some or all BIPA claims are preempted by the Illinois Workers' Compensation Act. The oral argument in that case was sort of a mixed bag. The court questioned both sides of the case pretty heavily. It did, perhaps I'm jaded, but it did seem like they were maybe weighing on coming down on the side of employers as they questioned the plaintiff's attorney pretty hard. However, we'll see when that issue is resolved via opinion. Perhaps the case to have next to Symphony of Bronzeville Park, the case to have the next biggest impact, or equally as big an impact as the Cawthron case that's pending in the Seventh Circuit. That case is set to decide when is a violation, meaning in particular for employers, are employees under BIPA able to recover for each time they scan in and scan out of a timekeeping system, which means they could potentially recover $5,000, let's say 4 times a day, if they're scanning in and out at the beginning and end of the day, and perhaps one or two other times for breaks. Obviously, such an interpretation would be extraordinarily detrimental to employers and could bankrupt many Illinois businesses, as White Castle's counsel pointed out during oral argument in that case. Again, that's another case where oral argument was recently heard, and we're waiting for a decision from the Seventh Circuit on that. The Seventh Circuit did suggest during oral argument that they might perhaps certify this question back over to the Illinois Supreme Court. Although given the decision in Rosenbach, many employers are hoping that the Seventh Circuit might decide the issue themselves. And lastly, as mentioned, there's the Article 3 standing issue in federal court, and the two cases mentioned there in the Seventh Circuit are cases which show that the Seventh Circuit has articulated that depending on the type of allegations alleged, as well as the claimed alleged, plaintiffs have the ability to craft their complaint in such a way that they could plead around the concrete and particularized injury that is necessary for standing in federal court and allow their cases only to be heard in state court. So that is an issue that's we've seen pretty clear indications from the Seventh Circuit, but is still relatively unresolved. So how could reform assist employers? Well, really, it could clarify all of the pending appellate issues. Do you need to suffer a particular injury to bring a claim, or is a technical violation alone sufficient? Obviously, if this is spoken to in amendments, despite Rosenbach giving us a decision on that, a clarification or an amendment could change that. And additionally, the statute of limitations needs to be clarified, as well as claim accrual. Are individuals able to recover on a per swipe basis, or is it just a one and done violation? And is there preemption under the Illinois Workers' Compensation Act or otherwise? And, you know, obviously reform has the ability, as discussed at the outset, to provide useful things such as a notice and cure period, which would allow the intention of BIPA to be served for individuals' biometric information to be protected, but to not have the negative impact on businesses that the current statute in its current form is having. Businesses could be allowed to be notified when they're in violation of the statute or alleged to be in violation of the statute, to cure this for the individual, and if they do not, to then allow the individual to bring suit under the statute, which seems to serve all the purposes of the statute without the negative consequences for businesses. So some food for thought there on the current issues and cases, and I'll kick it back over to Brad to continue the discussion. Thank you.
Great, thanks, Katie. No, that was very informative, and I think a good place to jump from for our next speaker. It's my pleasure to introduce Illinois House Republican leader Jim Durkin. Leader Durkin represents the 82nd district in the western suburbs. I believe he was first entered the General Assembly in 2006 and was elected leader of the caucus in 2013. To Jack's point earlier, there hasn't been a bigger champion for the business community than Leader Durkin in Springfield. And we're glad to have him here today. And I'll kick it over to you, Leader. Thank you for being here today.
Thank you, Brad. I appreciate it. And it's an honor to be with this distinguished panel. I'm in Springfield doing this web event. And I think it's interesting that while I'm doing this, talking about one of the most destructive areas within our tort system, that there is a fire drill going on in the Capitol. And at the same time, the federal panel is taking on our redistricting litigation. So maybe a message is being sent. I'm not sure what it is, but I hope it's positive. But there's a lot of things going on. And let me just say that we're going to start session up quickly. It'll be the first week of January. It's going to be a very compact session. Things have been delayed because of the redistricting mess that's going on. It was delayed because of census, and myself and also my counterpart in the Senate, Dan McConkey, we filed a federal lawsuit challenging the redistricting plan that the Democrats have signed into law. And as I said earlier, that is currently being heard by a federal panel in Chicago. So, but as we go into next session, I hope that we can address some real issues as opposed to just going through the motions as sometimes we do in an election year. This is an election year. We have primaries that have been pushed back to June because of the redistricting problem, and also the general election will be in November. What's interesting is that not only it's going to be all the members of the House will be running in new districts, also the Senate. We have all our constitutional offices will be up for election, from the governor all the way down to the comptroller. But also importantly, we will have a race for the Illinois Supreme Court, which will be very pivotal as we talk about business issues, particularly when it comes to BIPA. Right now, the composition of the Supreme Court is 4-3 Democrats, but there are 2 new seats, one in the collar counties and one in central Illinois. They'll be very competitive, very competitive. And as we think about the Six Flags opinion, a reconstituted Supreme Court could revisit that issue under the right circumstances. But we're here today to talk about a growing concern in Illinois. Illinois has had a tarnished national reputation for its tort and civil justice system. Attempts to rein in runaway verdicts even prompted President George W. Bush to appear in the Metro East to expose a destructive medical malpractice system. Despite efforts by the legislature to rein in that system, nothing has changed. Med mal and work comp premiums are higher than most states in the country. It forces these professionals and businesses to make difficult business decisions. Why try to run a business in Illinois? Why don't I just go a little bit east into Indiana? Why don't I go into Iowa? Why don't I go into Wisconsin because of the business climate? And that is a question that is being pondered daily. I had breakfast with a small business owner yesterday, not so small, who's subject to one of these lawsuits. And the first thing on his mind is, I have to make a decision at some point whether or not I'm going to continue to run a business, employ people in the state of Illinois, but I'm being harassed with these BIPA lawsuits. And it is harassment. It's really unfortunate. So as I talk about our medical malpractice problems, and we have generally problems we have in our tort system, a new area of abuse in our civil justice system falls under the Illinois Biometric Information Privacy Act, otherwise known as BIPA. It's not as sexy as nor a headline type of issue as med mal is, but it is becoming the biggest threat that we have in our business community. Not only businesses, our business community, but also nonprofits are part of this world too, and it's unfortunate. Now, as Jack said earlier, I don't think anybody who voted for this in 2008 ever really understood nor ever came to any type of realization of how this act has been, and I'll use the word bastardized and weaponized by a select group of lawyers and professional plaintiffs. Yes, there are professional plaintiffs who are part of the class action world. The system is run amok, and the only way to fix this is through a legislative fix. And that's what I've tried to do this past year. Now, as I think that Katie went through most of it, but the BIPA Act became law in 2008 and has really become it's unchanged. Nothing has happened since then. It's one of 3 states in the nation with protections for a person's biometric information. That's fine. That's absolutely fine. No problem there. But the current biometric law, privacy law, establishes requirements and prohibitions on the possession, collection, sales, dissemination of biometric information, and creates a duty to protect biometric data in an entity's possession. That's fine. But technology and commerce have changed drastically in the last 13 years, and BIPA must be updated to reflect these realities. Now, I remember back when I was a laborer, I actually had a job when I was working for 7-Up, and I was working in Public Works Department. I would punch the clock with my time card. That has kind of, it's not as reliable as we thought it was, because there are people who will take advantage of that system. It's not very reliable. There's time cheating, buddy punching, as we say, in the cards, and it doesn't really, it's not fair to the employer. So the Biometric Privacy Act is a way to be able to ensure that someone is at their job, doing their work at the times that they are scheduled to do it. But let me also say that, I'm a practicing attorney, and I've actually had to deal with issues regarding the overtime rules that have been changed by the National Labor Relations Board about being crackdown, which is a crackdown on the employers regarding the payment of overtime. This has forced our businesses to take on a more scientific and more reliable way to be able to determine one's time on the job. And that is why businesses are using this biometric system. It's the right thing to do, but they're doing it because of threat of litigation, which is occurring in the federal courts under the overtime rules. So they're kind of caught, you're doing the right thing, but you're also getting slammed at the same time under BIPA. And that's really, really, really destructive. So within the last 2 years, again, a lot of people don't understand much about BIPA. They don't even know what it means, but I've had to take it upon myself to listen and to meet with business owners who have come to me in my office to talk about this new threat of litigation. Maybe it's not so new, but it seems to be a new cottage industry that has built up with a select group of attorneys, as I said earlier, and also professional plaintiffs. So with the support and also the guidance from the the Chicagoland Chamber, the State Chamber, I introduced a few bills. One of them did make it out of committee. That was House Bill 559. 560 didn't get out of committee, but 559 seems to be the one that I felt was the one that was appropriate, one that had that was fair, it was responsible. It didn't completely gut the whole issue of BIPA litigation, but it put reasonable reforms into place. As it said here on the slide, it protects individual rights. It protects the manufacturers and nursing homes and also nonprofits from these frivolous, and I will emphasize, frivolous lawsuits where there are no damages have to be established based on the Supreme Court's opinion in the Six Flags case. But what I think is important on this, it's fair, and it provides for a notice and cure process for companies to cure a violation within 30 days of notice. You get one bite at the apple. That's all we said at this. If you don't cure, then you will go into, then the litigation can proceed. The litigation also, the House bill also created a 1-year statute of limitation. We had a very, very healthy debate within committee, and Brad was part of it, and also members of the business community. And I thought we had a good bill that was going to at least get a fair hearing in the House of Representatives, on the full House of Representatives. Despite having the bill passing out of committee with 10 votes, it failed to move after that. And I think a lot of you will probably ask why. And I'll be perfectly honest with you. There's a reason why. It's called the Illinois Justice Pact. That's what it is. Take a look at it. If you look under the State Board of Elections, it is it's a group whose purpose is to support candidates who share the ideology of our organization. Nothing more. But if you look at the donations that are made to the Illinois Justice Pact, they come from Edelson Law, big contributions. A firm out of New York called Bursar and Fisher, another big plaintiff class action firm. Schlichter, Bogard, Denton out of St. Louis, another firm out of St. Louis called Pfeiffer Wolf. The list goes on. And they contribute handsomely to Democrat leaders and also members of the General Assembly. Unfortunately, that is what we live at. That is what Springfield is about. All I wanted was a fair chance, a fair opportunity to have a healthy debate in front of the whole legislative body. Up or down vote, that's all I was asking for, but I couldn't even get a vote. So let me just say this. Elections have consequences. I mentioned earlier that all the legislative seats will be up for re-election this next year, new districts, and the governor will be up for re-election. As a Republican leader, I'm doing everything I can to field very strong, good, reasonable-minded Republican candidates to run in the House of Representatives throughout the state of Illinois. We feel that this election cycle is going to be extremely competitive, but also one based on what we're seeing with national trends, could be something that could be very positive, could be positive for Republicans, not only through the nation, but also in the state of Illinois. As I mentioned that we are a few seats behind in the House of Representatives. I believe that we are going to make gains in the House of Representatives, but also importantly, the Illinois Supreme Court will be extremely important this next election cycle. There is a chance that the Supreme Court could get flipped to a Republican control, which would be the first time in decades. So when I say elections have consequences, understand that there is political winds that are blowing very strong. But when I'm up against the Illinois Justice PAC, it makes it very difficult for me to be able to make a case before the House of Representatives. And I know that everybody, and I'm getting maybe a little bit off track with politics, but unfortunately, I'm living in a political environment. And I will just say that probably the only way that we're going to make reasonable changes to BIPA is not going to be through the courts. It's going to be through the legislative process. And my ability to win seats gives me the ability to negotiate and to use leverage. So I will continue to push House Bill 559, and maybe we need to look at the former Industrial Commission as a place where these claims should be submitted. And I know that there have been attempts and that there's been preemption bills that were put into the House of Representatives within the last year. But I think we're at a point that this system, as Jack said earlier, it's been weaponized by a select group of plaintiffs' attorneys who have taken advantage of a quirk in the law or something none of us ever believed would be advanced this way when it was passed in 2008. So it's unfortunate that this is another, I would say, black eye upon Illinois business community, Illinois business regulations and how we treat our businesses in Illinois. But again, until we are able to make advancements in Springfield and take advantage of this political opportunity coming up, it's going to be a long road ahead. But it doesn't mean that we will continue to work on this. I do know that there are Democrats who are very interested in trying to find a reasonable resolution to this issue of BIPA abuse within our court systems. So I'll just say I appreciate what you do and for supporting myself in this venture, but we will continue to move this issue forward. And we have to be able to make, let me just say this, we have to be able to make this an issue like happened years ago. As I mentioned earlier, when President Bush came to the Metro East area, it put a lot of attention on our medical malpractice system. We have to be able to treat this as a catastrophic issue that is going on with our business community. And we have to find a way to be able to discuss this in a reasonable, cogent manner to the everyday person in Illinois, because at the end of the day, business decisions are being made by those who have been sued under this law on whether or not they're going to continue to practice and keep their shops open in Illinois. What that affects not only is that business owner, but also all those employees who rely upon that business. We're going to have to make that tough decision at some point. So I'm open for any questions, Brad. Thank you.
No, thank you, Leader. And yeah, before we get into the Q&A really quick, we are going to turn it over to Jason Speaks with Leading Age Illinois. I will say, Leader, to your point on firms like Edelson, if you go on social media, there's targeted ads that, say, hey, is your employer collecting your fingerprint? And, call this firm. And you look through these comments and it's pretty scary stuff. So no, your point is very well taken. But again, we did want to have a business that is going through this right now and dealing with BIPA. So with us today, we do have Jason Speaks. Jason is the Director of Government Relations at Leading Age Illinois, which is the largest and most respected association of providers serving older adults in Illinois, from home and community-based care, senior housing, life plan communities, supportive and assisted living, and skilled nursing rehabilitation centers. Leading Age is doing a lot for our older adult populations. I was connected with Jason and his team last session during these BIPA negotiations, and he's been a great partner in this, and we're excited to have him here. So Jason, with that, I'll turn it over to you.
Thanks, Brad, to you and your team, the Chicago Chamber, doing some great work, and thanks for shedding a light on this issue with this webinar today. Brad already touched on kind of what our association does, who we represent. We're the state affiliate of two national associations in Washington, D.C., Leading Age and Argentum. He mentioned that the segment of the industry that we represent. On the nursing home side in particular, we represent the nonprofit segment of the nursing home industry. And as Leader Durkin mentioned, the nonprofits are hurt by this issue as well. Our members, nursing homes, assisted living, retirement communities, and our home care members were hugely impacted by COVID-19. It caused a lot of strain in various ways, particularly the large financial losses that our members experienced, and trying to do everything they could to keep the elderly safe, keep the elderly and their staff safe from the pandemic that is still continuing on, as you all know too well right now. Our nonprofit members, they already had challenges before the pandemic, and the pandemic and now BIPA has now further compounded those issues, and it can have a devastating impact if there's a BIPA lawsuit that comes into play. I wanted to give a specific example of the approximate 1,500 cases with BIPA. We believe that several hundred are focused on senior living communities. And we have signed on to 2 amicus briefs in 2 of the cases with BIPA, White Castle, and then one that's close to home in our industry, Lexington Healthcare, which is not a member of our association, but we're closely following that, as well as the Symphony case that Katie mentioned earlier, monitoring that closely and seeing the impact of our fellow nursing homes, whether they're our members or not. But 2 of our members in recent years were greatly impacted by a BIPA lawsuit. One being Smith Village, which is in the city of Chicago, a high quality provider like all of our members are, high rated, great staff and residents they take care of. And then one that's actually has a community, it's a multi-site organization, has a community in Leader Durkin's district in Homer Glen, Providence Life Services, a nationally renowned older adult care and services provider. Both are nonprofits and both were impacted by a BIPA lawsuit. Using Providence Life Services as an example to let you know how this impacts our nursing home members and assisted living and other senior living community members. They were using, as most employers are using and getting hit with BIPA lawsuits, the thumbprint check-ins for human resources. And like Leader Durkin mentioned, it's a good way to combat fraud. It's a good way to let you know if an employee is showing up to work and working those hours. And what more important industry to make sure that those folks are showing up and doing their work than in senior living. What they were doing with the thumbprints, their vendor was not storing the thumbprint, but they were creating a proprietary number and storing that number, very unique that nobody could guess the number or anything like that. But neither here nor there, Providence was hit with a class action lawsuit, even though there was no harm. They were hit with a lawsuit, and they were advised, instead of making a long drawn out process, to settle fairly quickly. And they did settle, and the settlement was for $3 million. They had to go back, they agreed to go back 5 years and look at all the employees that they had in that span of 5 years that used the thumbprint to check in for their shift. Of the $3 million, those employees that were in the class action lawsuit split $2 million, and the attorney that sued got $1 million of that. So that kind of shows, as Leader Durkin mentioned, the motivation that some attorneys have for targeting certain industries and certain employers to get a big check out of this. The employees that were a part of this lawsuit split the $2 million. They each got about under $500. And I think in the Symphony case, they projected that if Symphony loses, that each employee would get about $320. So again, no actual harm was resulted or caused this lawsuit in our cases. So luckily for Providence and Smith Village, they did have insurance that covered this. But if they were to get sued today, their insurance company, and it's a vendor that a lot of our members use, they've changed their policy and they will only cover $100,000 if a lawsuit like this transpires. So if Providence were to get, or Smith Village were to get sued today on this and were to settle or lose, they'd be liable for $2.9 million. And like I said, they've already experienced, along with a number of others in the industry, huge financial losses due to the pandemic. So this is a priority issue for our board that we discussed even last Friday in our board meeting. We discussed this being one of our top issues to combat. And we are very happy to be involved with the Chicago Chamber in lobbying and advocating for a reasonable solution to this. Thanks so much to Leader Durkin for all of his work, him and his team, and thanks to McGuire Woods for their work on this as well. And we're a happy partner to be involved to help with our segment of the business industry that's impacted by this. So just wanted to take a couple of minutes that we were allotted to just kind of talk about the devastating impact this could have on the senior living community industry, which is a vital part of every legislative district, every community throughout the state, taking care of our elderly. And, you know, a BIPA lawsuit could really close some doors to some nursing homes, and they provide such a critical need. And that's why we see this as being a major priority for this next legislative session. So again, thanks, Brad, for allowing me a couple of minutes to touch on this and the impact it's having on our members and the industry as a whole. And I will, out of respect for time, you know, pause here and allow you to move forward with the program.
Sure, great. And I'm not sure what's going on. Oh, there we go. So the slides are up and running. So yeah, we're gonna dive into a quick Q&A here. Leader, I did get a question from a member, a little more inside baseball, but wondering if you can give some insight as to what happened at the end of session last year. Language was inserted into the BIM. And I forget which amendment it was, but then it was quickly removed after that. And I'm wondering if you're able to give some insight as to what happened.
Well, I'll try to give some insight, but the fact is that the Democrats blocked us from any negotiations in the budget 2 weeks before session came to a close. But I'll give you inside baseball. It's real simple. It's called the Illinois Justice Group. They're the ones that do not want to see any change with BIPA. They like the status quo. There was, I know some, as I said earlier, some reasonable Democrats who were trying to do the right thing. And I know that the IMA and also different groups inserted that at the end. But once it makes its, rears its head, it doesn't go unnoticed. So this is strictly a protectionism operation for the that select group of plaintiff attorneys who are taking advantage of the system. But that's why they have lobbyists. They have lobbyists in Springfield that look for this. And that's why it was removed from the budget in those last hours of the legislative session. It had nothing to do with anything other than maintaining the status quo.
No, I hear you. I hear you. Another question, you know, in light of, I guess, to Katie, you know, in light of the evolving case law around this and what we're seeing with some of these pending cases, would there be a preferred or a suggested way of reform if it's going through the Workers' Comp Commission? The notice and cure has seemed like a clean and easy way, but there are many other ways to try and, you know, get at this. I'm curious to get your thoughts.
Yeah, I would say any reform at this point that gets through would be the preferred method, really. I'm seeing the roadblocks that we've hit and the adverse decisions that have come down from the courts, some of them adverse in the meantime. I think at this point, it really is, as Jason was saying, a hot button issue for all Illinois employers. And as Leader Durkin was saying as well, action really needs to happen in 2022. So I agree that the notice and cure provisions seem to be an easy kind of level playing field to preserve the intention of the act without the adverse consequences. So it seems like the right approach to me and not too heavy-handed, but obviously some movement needs to be made.
Yep, no, exactly. And Leader, I had another question come in, and this is I think a broader question, but to your point earlier, you know, I don't think anyone disagrees that regulation is important in this space. You know, I think there are privacy, you know, concerns, and frankly, I have, you know, concerns sometimes when a facial scan is taken or something like that. But where it goes too far is when they put in provisions like the private right of action and without statute of limitations, et cetera. How can the business community, even when regulation is maybe well-intentioned, push back against some of those types of provisions that get inserted?
Well, you got to start with your local representative and also senator. You have to make an appointment. You can't just send a form letter to that member of the House or the Senate. You have to actually spend time with them. And you have to be able to discuss exactly what this is doing to that employer, what is happening to their bottom line, how it's affecting their employees, their ability to grow and to be able to make that future investment in Illinois when they are being courted by the state of Indiana or the state of Wisconsin. But what does it mean right around now, the holiday times? What does it mean for that bonus that a lot of employees rely upon? But when you have liquidated damages that are not covered by insurance policies, this is a consideration that an employer has looming over his head and is not able to make the types of decisions that you would think that they want to do, which they'd like to, which is they want to keep their practice going. They want to keep that business going. Sometimes a little guilt goes a long way. You've got to be able to meet individually, make the time and effort to meet with that member of the House of Representatives and also the state Senate. You've got to be able to tell them the story that you have and how this has affected your business. And look, we listen to people when they come in and when we talk about job losses. It has a very chilling effect on a lot of people, and it should, but particularly on this piece of litigation that a lot of people just don't quite understand. It's got kind of a silly name to it. People think of BIPA, they don't know what it means, but what it means to that employer, if they unfortunately get tagged by one of those select group of plaintiff's attorneys, you really have no option. It's legal extortion. And to be able to defend it, if you're not faced with, you can't spend the 6 figures or even 7 figures to go through discovery process of this. And you have to look at, they'll come in and they'll say, this is what it's going to take for you to get rid of this lawsuit, which is going to be a ridiculous number, which comes out of their pocket. It's not coming out of their insured. So get in front of those legislators, That is the only way you're going to be able to do that. But also just remember, as I said earlier, elections have consequences. You got to fight back. In Springfield, bottom line is you got to have the numbers, meaning you have to have at least 60 votes to be able to get anything done. And that's my responsibility and job this next cycle, to add to what we have and to get close to that 60 votes.
Yep. No, 100%. And I had another question come in. Oh, and this is related to the what is it? The Privacy Information Protection Act, Katie. And it's a similar act to BIPA, but the questioner is wondering how those two acts kind of interact and why why some situations might fall under BIPA and some might fall under personal privacy.
So BIPA is overarching and all-encompassing, really, as we discussed earlier. And so the vast majority of any violations related to biometric identifiers, biometric information, which BIPA defines very broadly, are going to fall under BIPA. And so more often than not, those are where the claims are going to lie. Especially as a result of the statutory damages that are available, the high amount of them, and the wide variety of claims that can be brought under the various prongs of Section 15 of BIPA.
Sure.
So that would be the answer there.
Okay. Well, I know we are coming up on the hour. I don't have any more questions coming in. I do want to thank you all again for your time today. Again, the Chicagoland Chamber will be advocating for this in the spring session. We need all of our members there with us to Leader's Point, making phone calls, explaining how this law is impacting you. And even if it hasn't impacted you, the prongs of, private right of action and things like that, they are an affront to the business community, and they are coming after us on that front. So with that, I'll turn it over to Jack to close us out.
Great. Thank you again to all of our panelists for being here. Illinois House Republican leader Jim Durkin, as you can see from today, really a true champion for the business community. Katie Lennox of McGuire Woods, Jason Speaks of Leading Age Illinois, and thanks to Brad Tietz, our Vice President of Government Relations at the Chamber, for moderating. And thank you again to all of you for joining us today to discuss BIPA reform, a critical issue to operating a business in Illinois. It goes to the cost of business in Illinois. This is a critical issue. If we work together with Leader Durkin, with members of the business community, we can make change happen and help grow the economy and grow jobs in Illinois and make Chicago and Illinois a great place to live and work. So thank you again for joining us today.